In this video I want to discuss a constructive dismissal case that came up there recently in the WRC. It's an interesting case because it involves the question of a data access request by the employee. And the use of the general data protection regulations and the data subject and employee's entitlement to obtain records under the various Data Protection Act regulations and laws. This case essentially involved a data access request from the employee which uncovered a smoking gun sort of evidence, which resulted in a €50,000 constructive dismissal case win for the employee. First thing you have to understand about constructive dismissal cases is they are difficult to win because the burden of proof is on the employee. The employee must prove that they had no choice but to leave the job, and they must really satisfy two tests. One, a reasonableness test, and two, a breach of contract test. Those two tests would be A, the behaviour of the employer has been so unreasonable that the employee has had no choice, no option but to leave the employment, and two, that the conduct of the employer has been such that the employee is entitled to say the employer, is no longer going to be bound by the contract of employment. In other words, the employer is guilty of conduct which essentially breaches the contract of employment. Both of those things have to be proved to win a claim for constructive dismissal, and for that reason it's very, very difficult to win constructive dismissal cases. However, in this particular case, and before going to that actually, this particular case, I'd also always advise employees to go through the internal grievance procedures first and to exhaust those procedures, and then you can go along to the WRC or anywhere else and say, look, I'm coming here with clean hands. I've exhausted the internal procedures in the workplace. I've done everything I can to remedy what I say is wrong, and the conduct of the employer has been so unreasonable. I've behaved reasonably. I've used the procedures. I've availed of them. So I would recommend that. In this case, the employee worked in sales and had been recruited in Canada to work in Ireland. Difficulties arose with the performance of the employee, or at least with the satisfaction of the employer in relation to the employee, and the satisfaction of the employer, or the employer wasn't satisfied and basically saw the employee as a problem and clearly wanted to get rid of the employee. Now, when the employee brought claim to the constructive or to the WRC, it was on constructive dismissal, and as I've explained already in this video, it's a very, very difficult claim to win. However, the employee in this case had the foresight and good sense to make a data access request, and in doing so, the employer handed over various pieces of correspondence, emails I think, which showed quite clearly that the employer's intention was to get rid of the employee. For example, one of the employees or one of the emails says V is a problem that needs to be fixed, and then another one says, I am concerned that we are dismissing her without written notice. At the very least, we should have a quick conversation with our accountant or a lawyer. The cost of doing so could be expensive. There's another one there. I have a call scheduled tomorrow with our lawyer to discuss options with V. Remember that Irish laws are a bit more towards the employee. The EU socialists, don't forget. And the killer one, I've made up my mind, I'm letting her go in the next few weeks. So this is an email written by the employer or by a manager saying essentially that the employer had the mind made up to let her go, and therefore the WRC adjudicator says, on balance, I fully accept that the complainant's decision to resign was reasonable. The employer did not engage with the employee in any meaningful way. The complainant had impossible targets fixed upon her, and I accept fully that the complainant felt that the outcome had been orchestrated because, as it happens, it was. In other words, the data access request by the employee uncovered all of this email evidence that basically won her the case for constructive dismissal, and showed that any procedure that she might go through would have been a stitch up, would have been a sham, and essentially the written evidence from the employer internally in relation to this girl was that she was a problem that needed to be fixed and a problem that needed to be got rid of. The WRC adjudicator awarded her 50 grand for a constructive dismissal. That's 50,000 euros. A takeaway for the employer here is that you need to be very, very careful about internal communication, because all internal communication down the line may well be subject to a data access request, in which case it should be and must be lawfully turned over to the employee. The second thing is, if you're an employee, then you need to always consider getting or making a data access request to see is there any smoking gun evidence, such as we've found in this case. It's not often that you get evidence like this, which is going to be a slam dunk essentially, but this evidence here that this employee uncovered through her data access request allowed her to win a claim that ordinarily would be very difficult to win. That is a constructive dismissal case. I hope you find this video useful. If you do, you might give it a thumbs up down below, and it really floats my boat when people do give it a thumbs up and approve my attempt to explain in plain language Irish law. You may be interested also in subscribing to my YouTube channel. Thanks for watching.